is yours. Good afternoon.
Good morning. Good afternoon, Your Honors. My name is Jay Jackson. Rutherford County Bar, Davidson County. I live in Davidson County, but my practice is in Rutherford County. And I would like to reserve 5 minutes for.
5 minutes, yes, sir.
Okay. This case comes to this court. This is a parenting plan modification case, a domestic case, not quite as exotic as the case you heard before, but in any event, it's still one that is important to the parties who are involved in this particular dispute. A parenting plan or a petition for a parenting plan modification was filed by my client, Ms. Renee Lannom, on December 14, 2022. There was a trial after extensive discovery had taken place in the case, which took place in November of 2024. At the close of the proof, Mr. Scott Lannom's attorney moved orally pursuant to Rule 4102 for an involuntary dismissal, and the grounds for that were, in essence, that we had not shown that there was any material change of circumstance meriting the next stage, so to speak, of the case, which was the application of the best interest factors. The trial court granted that motion, and this appeal has followed. In essence, kind of want to go over with you a little bit briefly about some of the facts that were involved in the case. This parenting plan that is involved, which is part of the record, the original parenting plan was signed or was entered in October of 2021 as a result of the parties' divorce. It was an agreed parenting plan. It was entered not long before the trial was scheduled, but it was an agreed parenting plan. During the course of the trial, the mother presented evidence related to what she believed to be material change of circumstances that had occurred since the entry of the 2021 parenting plan. And I have tried to list those in terms of different specific things in my brief, but I want to kind of go through a few of those things with you. So some of the facts, and I think it's important to remember and to keep in mind that in this case, the case in chief, Ms. Lannom put her case on. Mr. Lannom did not present any evidence in his case in chief. He didn't present any evidence at all. In fact, Mr. Lannom never even testified.
But he didn't have any burden, did he?
Yeah, that's because at the end close of the plaintiff's proof, he made a Rule 41 motion to dismiss.
Understand. And that was their decision. They could have gone through, they could have presented their proof and made the same motion at the end of the close of their proof as well.
They could have, but we're here to decide, was the evidence that your client presented sufficient to carry the day, or at least to require him to put on proof?
Yes, Your Honor, I agree. And so the evidence, some of the evidence that was presented in this particular case related to the father not being in compliance with the parenting plan. And so I want to kind of go through a few of those. First off, Mr. Lannom had never provided the tax documents that he was required to provide for the years 2022, 2023, and 2024. He did eventually, I think maybe after we'd filed it, not long before trial, he provided something, but at the time the petition was filed, he had not provided any of those. Another thing that had changed since the entry of the final decree was that the mother had moved out of the marital residence that existed at that time, and then she had bought a house, and she had, she bought a house. She actually got her job. She actually also got some promotions related to that. And one of the things the trial court said related to her residence was that it was contemplated at the time of the divorce that she was going to get a new home. So the fact that she got a new home isn't a material change. And I don't agree, and we do not agree with that. And the reason we don't agree with that is this. If her new home, which the specific home she had and it was in, was not contemplated at the time of the divorce, because she didn't have it, she had not bought it. But what if she had bought a home that Mr. Lannom had thought was inadequate for the child, didn't have heating and air, didn't have air conditioning, was somehow something that Mr. Lannom had objected to, or something that had put the child at risk of harm, and the way Mr. Lannom had thought? Is the trial court's would the trial court's view of that should have been the same, would be the same? Well, it doesn't really matter if she was going to get a new home. Doesn't matter that her home's not adequate. So the fact that she's got an adequate home and a good home, we don't believe negates the fact that it's still a change of circumstance as it relates to the child. Also, there's a couple other things that we felt like are pretty important to keep in mind, and that is that we pointed out in our brief multiple times where the father was not in compliance with the parenting plan. So, for example, non-emergency health care. We presented evidence that the father had not, the non-emergency health care decision-making is joint, and we had provided evidence that the father had not provided the mother with evidence or with information related to non-emergency health care, like physicals, different things like that. Also in the decision-making, which is joint, it was related to the school, the educational decisions, and the religious decisions. We presented evidence that the father had enrolled the child in a religious preschool without notifying the mother or talking to her about it, getting her consent, or doing anything along those lines. There's a lot made in the brief of Mr. Lannom that and also mentioned by the trial court, this was just some sort of a daycare. Well, there was no evidence that there was a daycare, and that's the whole point. If Mr. Lannom had put on evidence and had brought somebody there and presented proof that, well, this is just really a daycare, this is how it's structured and how it works, then there would be evidence in the record there was daycare. There was no evidence in the record to support the trial court's conclusion that this was just a daycare. And in fact, the only evidence that was in the record to support the conclusion was that it was a religious-based preschool, because that's what the mom testified to, is what her understanding about what it was. In addition to that, the father enrolled the child in Vacation Bible School. Again, a religious decision that he had not, talked to her about or dealt with her. The father had not provided the mother with any information related to the health care card information. So, for example, he's required to provide the health insurance. He did not provide her with that health card information. So she didn't have it for 2022, 2023. I think she got it in 2024. Literally, he gave it to her at the deposition, which was right before trial. It was the first time she'd ever gotten a health card information from the trial. And the trial judge said, in his opinion, he said, well, there was no evidence that she didn't get any of this health care information. Well, there absolutely was evidence. And I pointed out in the briefs the specific portions of the transcript where she specifically testified, I never got the card. And so I'm not real sure how the trial court came to the conclusion that there was no evidence that she didn't get health care information.
Was there any evidence that the child was deprived of requested health care because she didn't have a card?
Let me think for just a second. I'm trying to think.
That doesn't excuse the father from providing.
No, I cannot from memory say that there was. I want to say that there was some testimony that she had difficulty related to getting health care because of the lack of a card, but I can't say, okay, I can't tell you or represent to the court that specifically.
Thank you.
Your client here was asking for a change in primary residential parent.
Yes, Your Honor.
So, what I keep going over, though, is let's say the court accepted as true, which I'm not sure the court did everything your client testified to based on the adverse credibility determination. How does that rise to the level of a material change of circumstances significant enough to change the primary residential parent?
That's not an easy question to answer, because it's kind of like it's out in the eye of the beholder. And that's one of the problems, is that the standard that the appellate courts, if y'all's courts kind of look at, you defer a lot to the trial judges. And so it's almost like, you know, there's some case law talking about, well, you don't tally up the factors, you know, 5 factors for the mom and 6 factors for the husband or dad, so dad wins. So we just feel like the totality of the information that we provided is enough to trigger that burden of proof. And I know I'm going past my time, but I'd would like to go into my other time just a little bit, just to say this, and that is that we presented evidence of violations of the parenting plan. And what we can't do as a court system is tell parents, well, you can violate this part of the parenting plan and you're okay and you're not going to be punished for it, but you can't violate that part of the parenting plan. And so my client, Ms. Lannom, is in this saying, well, he didn't do what this parenting plan says he's supposed to do, so what's my remedy? And basically what the trial judge is saying, it's no big deal. And that's not good public policy. And so that's why we feel like that we presented evidence of material of violations. They were significant, they were material, and it was enough to trigger the burden, as you had said.
All right, thank you. We'll hear from you on rebuttal. Mr. Caparella. Good afternoon.
Good afternoon, Your Honors. Don Caparella, Nashville Bar, representing Scott Lannom. The trial court essentially found that this principle of law applies. Minor or isolated infractions of a parenting plan rarely constitute a material change of circumstances. And since as Your Honor pointed out, Judge McBrayer, that when you're trying to change the entire custody, you have a heightened standard. You have to show that whatever changes occurred affected the child's well-being in a significant and material way. And that is where this fell short, and the court found that, and the evidence doesn't preponderate against the trial court's findings. There was a discussion about this health care card, and Your Honor asked about whether there was any evidence the child was provided of any health care, and I think my opponent said, no, there is not. What essentially happened is that or at least the mother testified to, said she didn't get the card, and she had a text saying, from the husband saying, I'll send you the card. But he did eventually send her the card. That's what she said. More importantly, it's undisputed in the record that the child had a pediatrician. The child's only 3 years old. This case went from a 2-year-old child at the parenting plan that was agreed to a 3-year-old child with a petition was filed. It's undisputed that the insurance card was at the pediatrician's office. So there was no dispute that this issue with the card affected the child in any material way or a meaningful way, so therefore that's not a material change of circumstances. The other issues that were raised here, I think, just sort of fall away pretty easily. The trial court found, after looking at an extensive amount of text messages, that the communication was effective enough in this case between them, therefore that didn't rise to this level of material change of circumstances. After all, another key principle that applies to this case is that custody modification is the most drastic remedy and should only be used in extreme situations. And the trial court did not find that this was an extreme situation, so therefore the evidence would have to preponderate against that finding. And it doesn't preponderate against that finding, and given the fact that the trial court also made credibility findings against the mother, cast grave doubt on any of her allegations in her prima facie case meeting this. And the trial court didn't just say she's not credible. The trial court gave a couple of examples and also said, I'm also relying upon prior times in the previous divorce that I found her to be not credible. So,
And the court found her expectations of communication with and from father were not reasonable.
correct.
If I understand.
That's correct. She wanted extreme detail, for example, when the father took a trip, but the court found that he said where we're going, how we're getting there, when we're going to get there. He gave enough detail to meet the standard, to not make this a drastic failure in communication, that it made the parenting plan unworkable, which is the standard under the heightened standard for changes of custody. This interesting thing about the the child being signed up for a preschool, we'll go with a preschool because that's what the mother called it. I think there was some suggestion it was a parent's day out. I'm not sure what the difference is, but the child's 3 years old going to this preschool, and the mother testified that the child was thriving in this preschool and goes into detail about the different ways the child is thriving. So how can that be a material change in circumstances if the father sends the child to a preschool when the child is 3 and the mother says, and she's thriving there, but he didn't ask me first, therefore custody has to be shifted? That's where that fell short. Regarding the Vacation Bible School, at the end of that week of the Vacation Bible School, there's a text message from the father saying, child's having a great time, why don't you come to the picnic at the end? And the mother thanks and says, thanks very much for telling me about this. Hope the child has fun. I do wish that you would consult with me about these things in advance. Again, no effect of the child's well-being being negatively affected by this child going for 1 week to a Vacation Bible School. It's not like she objected to the Vacation Bible School. She just wanted to be told in advance about it. So we submit that they have not shown that the trial court made any mistakes as far as showing that the evidence preponderates against the trial court's finding. Now, we've also asked for the attorney's fees that the trial court awarded to be upheld. It was about $15,000 in attorney's fees. Father has not challenged, did not challenge at trial, mother did not challenge at trial those attorney's fees as being unreasonable. The court just awarded them based on an affidavit. It's Exhibit 12. And on appeal, mother simply says that father's not entitled to the attorney's fees under 365103C when that statute very clearly says that if you're the prevailing party defending a child custody change and you win, you're going to get attorney's fees. And there is no issue raised at the trial court or the Court of Appeals that the fees were unreasonable, so therefore we submit that they should not prevail in that as well. And then lastly, I wanted to talk about our attorney's fees request of appellate attorney's fees. It's very common that courts will seriously consider awarding attorney's fees on appeal under 365103C when they've been awarded in the trial court, because after all, a father in this situation has had to defend an agreed parenting plan that was where the petition was filed just 13 months later when the child had gone from 2 to 3. And the mother had agreed to it, and she'd gone through her drug testing plan, so the parenting plan had gone through fine, so they were functioning well under the plan, and yet father still has to defend it, not only in the trial court, but on appeal, and he should not have to pay to defend an agreed parenting plan when the mother essentially, as the trial court found, had buyer's remorse because she didn't like the parenting plan she agreed to. So this is a perfect example where the court should exercise its discretion and grant attorney's fees on appeal when mother failed to even make a prima facie case in the trial court. And if you affirm that, I think that even makes our case for appellate attorney's fees even stronger. Unless you have any questions for me, I don't have anything else I need to say.
Hearing none, thank you, Mr. Caparella.
Thank you.
Mr. Jackson, your rebuttal.
Just to start with a couple of things. It is an agreed parenting plan. And Ms. Lannom did agree to it. She signed it, but so did Mr. Lannom. So a lot of these things that are in here that we brought up are things Mr. Lannom agreed to. So, for example, the preschool or the religious part of it. The fact that the child happens to be doing well in it after the child was unilaterally enrolled in it is not relevant. It doesn't matter. What matters is what the parenting plan says and you're required to consult and discuss it. It's a joint decision. The father violated the parenting plan when he put the child in that setting without consulting the mother. Now, that's something. I mean, that is certainly those are the kinds of things that it's really hard. Like, when the legislature creates this parenting plan, and they create this form, and it's got a lot of pre-printed words in it. And you set all these different things out. And it's like the game plan that these parents are supposed to have in order to raise this child. Some of them get along well, some of them can't. But if we start, picking and choosing what parts of this parenting plan you get to, well, it doesn't matter if you violate this, it doesn't matter if you violate that. Well, yeah, it says you're supposed to consult the other parent about the children, and you agreed to do that when this was a divorce, but if you don't do that later on, it's okay just so long as the child is thriving. No, that's not the way it should be. We should hold parents accountable to their agreements. They want my client held accountable to her agreement. Mr. Lannom should be held accountable to what he agreed to. And the reason why he doesn't do these things is because he is such a poor communicator. The trial court even made a comment. He's a man of few words, I think is the way they used it. He's not a man of no words. He does not. If you go through, and it's in the record, and you go through these text communications, y'all look at them yourself, and you read them, and if you think it's adequate. He doesn't even respond to many of them. Now, does my client go on longer than maybe she should at times? Probably. Okay, I'm not going to doubt that for a second. But she's asking some very basic questions that she's not getting answers to. And so, it's not just the lack of verbalization or talking or however you want to put it in the messaging. It's not just that. It's the not communicating about these decisions, not letting her come to the physicals and all these different things that happen in this child's life as this child gets older. All those things together are problems, and they inhibit each parent and inhibit my parent from being able to maximize her time as a parent with this child. And so I'd ask the court, as you look at this, I understand the burden that she decided to pursue in court was higher than the burden if she tried to just get equal time and not change the PRP status, for example. I know the statute's different on that, and I understand that. But we have evidence of clear violations of this parenting plan. And sure, you could do like the trial court does. Well, it's not material. They don't matter. And I know there's case law out there that talks about that. But what are we telling parents? If we tell them, well, some of it's material and some of it's not. How are they supposed to figure that out?
But there are other tools available to a trial court to address these concerns. I mean, the only tool is not, well, you're not abiding by the plan, we're going to change the plan. I mean, the court has other tools, do they not?
They have contempt tools.
Sure.
Sure, they do absolutely have contempt tools.
And why shouldn't we favor that approach other than, because when you mess with the plan, change a plan, that doesn't just impact the parents, it impacts the child.
Well,
and so that's an upset for the child.
So let me tell you why you don't do that. The reason why you don't just rely on contempt is because what we're really concerned about ultimately is how the child does. And contempt's not going to solve the problem that's created from that parent's disobeyance of the parenting plan. It's not going to help the child. What helps the child is changing the parenting plan to get the child out of those circumstances. That's what helps the child. You can put the dad in jail or mom or whoever it happens to be, but ultimately the goal should be to help the child. The contempt powers do punish the parent for violating an order, and they should be held to that, but they don't help the child.
All right.
Thank you.
Thank you, Mr. Jackson and Mr. Caparella, for your arguments. We'll take this matter under advisement. Thank you. Call the next case, please.
Artistic Builders, LLC versus Jeremy Whitaker et al.